There have been several questions floating around in the media since the resignation letters of the Chief Secretary of the Tobago House of Assembly and his executives and his other members of the THA Assembly have been made public. Now, these letters are the documents whereby they effectively resign their memberships in the Progressive Democratic Patriots, the PDP, which is the political party through which they contested the THA elections and through which they got into office. The issues arising would be whether they now have any legal standing to continue in office, given that they are no longer members of the party which they came into office with. So they came into office as members of the PDP. They are now no longer members of the PDP at all. All right, so they are independents as they have described themselves. So the question now is, what is the status vis-a-vis the continuation of the functions and operations of the Tobago House of Assembly? Now, on the face of it, it is clear that there is no corresponding provision to Section 49 of the Constitution, which provides at 49(2)(e) that a member of the House of Representatives, that's in the National Parliament, right? So a member of the House of Representatives in the National Parliament shall vacate his seat, and this is in a situation where Section 49(2)(e) says, having been a candidate of a party and elected to the House, he resigns from or is expelled by that party. Now, if you look at the THA Act, and even if you look at the amendment which was made in 2021, that's the amendment which increased the seats from 12 to 15, you recognize that there's no similar provision in the THA Act. There's nothing that speaks about if a member resigns from the party which elected him to the House, or if he's expelled from that party. So on the face of it, it would appear that there is merit in making such a move, in that it would appear on the face of it that, look, there's nothing in the THA Act which prohibits this, which speaks against it, or which forbids it. The only thing that one is left to consider now is the effect of Section 92 of the standing orders of the THA, the Tobago House of Assembly. So you see, you have the Tobago House of Assembly Act, and you also have the standing orders. So the question now is, what is the effect of Section 92 of the standing orders? You would recall that when there was the 6-6 debacle, there were persons who were saying that, look, resort should have been had to the standing orders of the National Parliament to resolve this issue, because the THA Act was silent on it. So let's look at what Section 92 of the standing orders says. Section 92 says, in any matter not herein provided for, resort shall be had to the usage and practice of the House of Representatives of Trinidad and Tobago, which shall be followed as far as the same may be applicable to this assembly, and not inconsistent with these standing orders, nor with the practice of the assembly. In cases of doubt, the standing orders of the assembly shall be interpreted in light of the relevant usage and practices of the House of Representatives. So in other words, it seems to suggest that if something is not provided for in the Tobago House of Assembly's standing orders, and it is clear that there's no provision there which deals with the issue of when someone resigns or is expelled from the party which elected them to office in the THA. There's nothing there. So the question is, can we now have regard to what occurs in the national parliament? Can we have regard to the usage and practice in the national parliament, in the sense that we have the clear wording of section 49 2E of the Constitution, which basically says, look, in such a case, you must vacate your seat. So, in other words, does that trump this to say, well, look, the fact that the THA Act is silent on it, can we use the standing orders in this way to bring in the relevant provisions of the national parliament to say, look, under the Constitution, by section 49 2E, the members of the THA who no longer belong to the party which elected them to office must resign. Now, it's a matter that is for debate and discussion, and of course, one would imagine that we will see legal challenges being mounted one way or the other. But the interesting aspect of it is that the THA Act appears to have been specifically silent on this point, even though it was drafted after this 1978 amendment to the Constitution. So in other words, in our Constitution in 1978, we made this amendment for what is known as the crossing the floor provision. Right? So in other words, if you cross the floor and you leave your party or you're expelled from your party, you have to give up your seat, a by-election is called, etc. Right? So we know that. That's clear. The question is, does that equally apply to the THA, notwithstanding the fact that the THA Act is silent on it? And can we use the standing orders of the THA under section 92 of the standing orders to say, well, look, the standing orders speak to a scenario where if the standing orders are silent on something, then you can have resort to the practice and usage in the House of Representatives in Trinidad and Tobago. And of course, the practice and usage in the House of Representatives in Trinidad and Tobago is if you leave the party, you lose your seat. So therefore, you are the seat goes up for by-election. So it's going to be very interesting, and I think it's only a judicial determination and a ruling on this matter will put this to rest at this time once and for all. The question remains, would these standing orders, would section 92 of the standing orders bring into play section 49 2E of the Constitution so that you are able to say, look, those persons who have left the party or who have resigned from the party must give up their seats also in the THA? Or is it that you are saying, look, since the THA Act was drafted after this 1978 amendment to the Constitution and it specifically said nothing about that, is it that you are to say, well, look, it was considered and rejected and left out deliberately by the framers of the THA Act and those who wanted to, have that legislation put in place without this safeguard of the crossing the floor provision. So, interesting times ahead, and we will see how this plays out in the national space, one way or the other, if there is any litigation, and certainly a court ruling may be necessary to determine this issue.